Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, new USCIS rules could mean higher fees and denied work authorizations for some migrants. And we dive deep into the DACA arguments before the Supreme Court last week. All that's just ahead. But before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you like to get your podcasts. And as always, if you're going to leave us a review, it's going to help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts and check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. You'll find her on Twitter at BPC_T Brown. Hi, Theresa.
Hi, Jordan.
And Cris Ramón, Senior Immigration Policy Analyst. He's on Twitter at CRamonBPC. Hey, Cris.
Hey, Jordan.
Okay, all eyes have been on the Supreme Court this month as justices heard arguments over the Trump administration's efforts to wind down DACA. But our first story has gotten, considerably less attention, but could have major significance. So earlier this month, the U.S. Citizenship and Immigration Services proposed new fees to access immigration benefits, which included increasing the citizenship fee and a $50 charge on those seeking to apply for asylum status. Cris, can you give us a rundown of all these proposed rules?
Yeah, so the proposed rule has quite a few increases for certain immigration benefits, and some of them being a little bit unprecedented in the history of what USCIS has charged or not charged for these benefits. So let's go into the increases. An application for permanent residence, registration, or adjustment of status, so basically being able to get a green card, increases from $1,140 to $1,610. A naturalization request, so to become a citizen, increases from $640 to $1,170. Now, here are the other two things I think are really important because they've never been charged before. One of them is a $50 application for individuals applying for asylum, making the United States potentially one of four countries that will be charging for asylum protections. We also may be charging DACA recipients $275 for the application, and they weren't being charged for this before. Now, individuals have DACA status, and obviously we'll be talking about that in this podcast. The fees that they will have to pay for this benefit will be going up as well in multiple ways. So that's what we look at the increases. One thing or two things that really haven't been getting press, though, is H-2A and H-2B visas, so that's temporary agricultural workers and temporary construction workers. Those fees actually dropped. For H-2A ag workers, it dropped from $460 to $425. And for H-2B construction workers, that dropped from $460 to $395, which is pretty interesting given the fact that right now Congress is sort of thinking about a bill to make it easier to bring agricultural workers to work in the United States. So that's that. I think the last point to be made is that fee waivers for individuals who are below the poverty line may be eliminated as well. And might make it harder for them to be able to pay these fees for these immigration benefits.
So these efforts have been controversial because what isn't in these days when it comes to immigration? But they're not unprecedented, right? Other administrations have taken these kinds of efforts in the past.
Sure. So a couple of things to understand. U.S. Citizenship and Immigration Services is unlike other parts of the government in that they are required by law to cover almost all of their budget with fees. So the fees they charge to applicants and petitioners for immigration benefits must by law cover their costs for doing so. 95% of USCIS's budget is fees. It's not appropriations from Congress. So every administration periodically does what they call a fee review. They look at the costs of adjudicating various kinds of petitions and applications, and they adjust their fee schedule accordingly. The last time the fee schedule was adjusted was in 2017, and the average increase at that time was 21%. Now, just like Cris said, in each of those time periods, some fees went up, some fees went down, but the average across all of them was an overall increase. And the same here. This is another overall increase of about 21% on average. And that is because, as Cris noted, some forms went up quite a bit, like naturalization. Others went down, but maybe not down so much. And so I think what happens every time a new fee schedule is announced, immigration advocates look on balance at those petitions and applications that they see their constituencies mostly using. So if you're talking about family-based immigration filings that are going up, including the adjustment of status filing for members that are adjusting in the United States, naturalization is a big one. Advocates always want to advocate for decreasing naturalization fees, making it easier for people to get citizenship. So an increase there usually causes advocates to have concerns. But overall, if the question becomes, did USCIS appropriately measure their costs in deciding this? Was it fair? I think the things that are going to draw concern and or opposition on this one is, as Cris mentioned, that fee waivers. So there's always been the possibility, if you can show that you are of low income but you qualify for these benefits, you can request a waiver of the fee. And those have been generally granted. But this administration, consistent with its public charge rule, is going to say fee waivers are not really available. So that's going to be a place where they're going to get a lot of pushback, I think, from the immigrant advocacy community. Also, as Cris mentioned, it is unprecedented for the United States to charge a fee for asylum. And there's two reasons for that. One is just in general, we don't think previously administrations have said it's not right to charge people who are seeking protection, who are fleeing, who are basically forced migrants, to charge them for an application for their protection. We don't charge refugees overseas, for example. In addition, it is been the case previously that there's been a surcharge charged on every other type of petition or application to cover the cost of adjudicating asylum benefits. My guess is that the $50 does not cover the cost of asylum adjudications. It is a nominal fee, and the only reason to charge a nominal fee, I think, is deterrence. So I think that's a place where you may actually see litigation against this part of the fee rule, and whether or not that's a legitimate fee to claim. If it's not actually covering the cost, if other petitions and applications are supposed to cover this cost, why are we charging a fee for asylum?
So separate from this, USCIS has also proposed some changes to when and how some asylum seekers can get work authorization. So what's the thinking behind that step?
Sure. So under law and regulations, someone who has applied for asylum either directly with U.S. Citizenship and Immigration Services or an immigration court, after waiting 150 days is eligible to apply for work authorization. The rationale has always been that, again, you are a forced migrant, you're here seeking protection. It's not fair that we make you wait without any means to support yourself and your family for that adjudication to happen. However, the administration, this administration, and frankly other administrations, have seen that as a potential draw for people to make false or not eligible asylum claims. And so, again, this is probably a means for them to deter what's happening at the border, work authorization for asylum being a draw. The proposal would say that if you applied, if you were apprehended between ports of entry and then applied for asylum, you would not be eligible at all for work authorization. And for others, if you had been convicted of a felony, you would not be eligible for work authorization. So again, this is one of those places, anything asylum related, where asylum and refugee advocates are going to probably denounce this, and they are saying it's a means of, again, deterring asylum seekers from seeking asylum in the United States. It's not necessarily protecting anyone, and it means that individuals could be waiting in the United States a long time without a legal means to support themselves and their families.
Yeah, one of the key issues that advocates have been raising is that it kind of undermines the integrity of the immigration system writ large, because if these individuals aren't able to work legally, they might have to seek out work in the underground economy, which is not what you necessarily want to see happen. So there's certainly concerns about what this means more broadly for ensuring that the immigration system works the way it's supposed to be.
All right, we'll be right back with DACA's day at the Supreme Court. Okay, let's turn now to the main story, the Supreme Court arguments over DACA. And I want to start by looking at how this case made its way to the Supreme Court. It's been a long path, and it's helpful to review it step by step. So, what's the DACA program, and what do we know about the people who enrolled in it?
So the DACA program was a program that the Department of Homeland Security issued through a memo. This is really important because people have been saying that President Obama issued an executive order creating that. That is not true. It was a DHS memo that was signed by Janet Napolitano, who was at the time the DHS secretary in 2012. The program really had two large components. One was deferred status, which essentially is a discretionary power that the government can say, we will not deport this individual or this category of individuals, paired up with a work authorization so that individual who receives this benefit can work in the United States. Now, in terms of the overall broad population, there's estimates about 800,000 individuals received DACA benefits since 2012. In terms of these individuals, average age is 25, but the oldest range is really when you're seeing at these individuals is 37 years old, which I think is important because people try to sort of portray them as kids. These are adults. These are kids who have grown up here in this country, who have families of their own. So that's important. Most of them are Mexican nationals. Most of them live in California. And in terms of just sort of where they work, they tend to work in higher skilled professions compared to other individuals who are, same background. They came to the United States without authorization when their parents brought them. Those individuals tend to work in lower skilled ones, whereas DACA recipients tend to work in higher ones, particularly in office support positions. So that's kind of the big broad picture of sort of what the program is and who it served.
All right, so why then and how did the Trump administration end the program? What were their arguments to justify that?
So basically, it's kind of funny because this all happened around the time I started at BPC. So this is kind of tracked with my tenure at this wonderful organization. Literally within 2 weeks of me starting at BPC in mid-August, a group of Republican attorney generals came to the Trump administration and said that they were going to sue the administration for DACA, claiming that it was illegal. Some of these attorney generals were the same attorney generals who a couple years earlier during the Obama administration did something similar for the DAPA program, which is a similar program for the parents of DACA recipients. So they came to the administration and said, we're going to sue this, it's illegal. The administration then turned around and in September of 2017 said, you know what, we're going to end the program. Then Acting Secretary Elaine Duke of DHS issued a memo basically saying that the program was illegal and that's why we're going to eliminate it. Immediately from that point on, you started seeing a lot of litigation around this, and basically claiming that the administration ended the program in an arbitrary and capricious manner. That again, the justification for ending the program wasn't legitimate. In response to that, in June 2018, then Secretary Kirstjen Nielsen issued another memo that tried to sort of expand the reasons, including noting that the reason to end the program is it sort of undermines the enforcement of the nation's immigration laws. But litigation remained ongoing, and the Trump administration, as they've done with other litigation related to their immigration policies, continued pushing this to the Supreme Court, leading us up to the hearing that we had in November of 2019. So this has been a process that's taken about 2 years to kind of fully realize itself before the judges who heard it, this month.
Yeah, a couple of other things just to add to that the initial courts did issue injunctions against the termination, so that kept the program alive for those who had DACA status at the time, so they could continue to apply for extensions of their status in the meantime. However, it did not allow any people who aged up into the program to apply for the first time. So the original parameters of DACA said that you could apply if you entered the country before the age of 16, that you had obtained at least 16 years and applied before you were 30. So for anybody who aged up into that lower age bracket that would have been eligible for the program, they could not apply. So, several 100,000 people who would have qualified for DACA were not able to apply since the termination went into place. But around 660,000 still have DACA status now or in the process of extending. So that's the population that are still eligible. The other thing I just want to point out is that the administration tried once before to get the Supreme Court to weigh in before all of the underlying courts had issued appeals. The Supreme Court declined at that point to take up the case. They wanted to wait until all of the appeals at the lower courts had gone through, and so that's when they're taking it now. So there's 3 consolidated cases that went before the Supreme Court, one out of California, one out of New York, and one out of D.C.
All right, so walk me through the kind of progression of those three cases. What have the lower courts said? I know you mentioned the injunctions, but what was the substance of their ruling?
Sure. So there are two issues at play. The first is whether or not the case is one that the courts can actually look at. The legal term is it justiciable, which is a big fancy term that means, is this something the courts are allowed to review, or is this something that is purely within the exercise of the authorities of the executive branch and the courts have no ground to review it? The lower courts said yes, this is a case that is justiciable. In part, they argued that the reason that the government gave was that the underlying program was illegal, but that question had not been determined by any court previously. As Cris mentioned, there was a threat that it would be sued, and it wasn't actually done. So it hadn't necessarily been decided that it was illegal. And so because that was the underlying rationale, that made it justiciable. The second question was whether or not the administration, in deciding to terminate the program, took in consideration all of the extraneous factors. The fact that almost 700,000 people were relying on the program, and not only them, but all of their employers, their universities or higher education institutions, their families and the communities around them also were relying on this program to allow them to keep working and supporting them. Therefore, there was what was called reliance interests on this policy that should have been taken into account before the policy was rescinded and were not. So that's sort of the second part of it. That question is important for determining whether or not this termination was arbitrary and capricious, which would make it violate the Administrative Procedures Act. So that's sort of the ranking of the legal terminologies that were at play.
Yeah, I think the one thing to note with the arbitrary and capricious and the APA is that since the DACA litigation, that's actually been one of the primary ways that immigration advocates have been sinking the Trump administration's policies and a whole host of different issues that they've been doing these APA challenges. So in a lot of ways, this litigation kind of foreshadowed what would happen over the next 2 years as the Trump administration would release a policy and then advocates would then sue.
All right, let's take a quick break, and then we'll get to the hearing and what happens next. Stick around. Okay, so that all brings us to last week's Supreme Court hearing and what the court's rulings next year could mean for DACA recipients. A lot of media coverage seemed to portray this case as one about whether or not DACA will continue, but that's not really what's being argued. So, Theresa, what's at stake here?
So I think you're right. A lot of people, and particularly I think in the advocacy community, has said that, they want the court to rule in their favor so that the DACA program will continue. And theoretically, that could happen. The Supreme Court could say that the Trump administration did not terminate the program properly. That would essentially mean the program would have to continue, but only until the administration decided to re-terminate it properly. So there's no guarantee that a Supreme Court ruling will mean that the program will continue in perpetuity. It just means, again, we're going Administrative Procedure Act. The question is not whether the DACA program itself was legal or not, honestly. The question is whether or not the termination was done properly. If the court says the termination was not done properly, the administration can still go back and do it again, in this time in the way the court says they should have done it, and the program ends. It's not going to give anybody permanent status. And that's the thing I think that gets confusing. The court cannot give permanent status to anybody.
Yeah, and I think one of the things that kind of adds to this confusion is the fact that the administration continued litigating this case when it could have, at any given moment, actually just simply issued a new memo that kind of would have addressed the substance of these challenges and ended the program. I think the thing to think about there is that the fact that they pursued it meant that they maybe wanted a ruling that might be more favorable to their ability to really limit the capacity of future presidents to sort of be able to issue wide-ranging immigration policies through executive memos. So I think that that's something else to think about.
And that was something that the plaintiffs argued before the Supreme Court. They actually argued that the way the administration has gone about doing this, they actually wanted the court to be the bad guy on DACA, and they wouldn't have to take responsibility for it. They could put it through the courts, and the courts would say, no, this program doesn't belong. And they argued that abdication of political responsibility is another reason why the courts do have the ability to weigh in at this point.
So neither of you are lawyers, although it does feel like we're all getting a free legal education over the last couple of years. But what's your read on how the arguments went last week and how the court received those arguments and any sense of where the court is going to land?
So reading through the transcripts, I'll tell you what I saw. And again, bearing in mind we're not lawyers, the liberal justices did lean in very heavily to the administration on this idea of whether or not they had made sufficient arguments and whether or not they had sufficiently considered all the reliance interests in this case in making the determination. The government's, the Solicitor General, Noel Francisco, insisted that they had. And not only the Elaine Duke memo, but the later Nielsen memo said, they were addressed. They may not have been addressed in depth, but they were addressed sufficiently, and the government did consider it. The conservative justices, Neil Gorsuch in particular, pressed on that a little bit and pressed on the plaintiffs to say, okay, so what's the benefit of sending this case back? If we rule in your favor, it goes back to the lower courts, and the government takes another 3 years to issue a better memo with more rationale. What's the benefit in doing that? So I think he was getting to this point that at the end of the day, the program would probably be terminated anyway. Does a decision from us sending it back to the courts actually gain anybody anything? And I think that's a key question to ask. If at the end of the day, the administration is bound and determined to end the program and there's a legal way for it to do it, you're not necessarily gaining anything but more delay. But for the plaintiffs, and again, for the DACA recipients, delay is better than not, right? So I think that's why they're arguing it.
I think one of the other things that was interesting is just sort of in the posturing of how the questions and statements were made is that the conservative justices kind of acknowledged the obviously the human dimension of this case before then going into the harder legal questions of whether or not these decisions could be reviewed and whether or not the program was ended in an arbitrary and capricious way. Another thing to note is that there might have been some issues with understanding how the program functions. Chief Justice John Roberts was talking about this program, saying that it was largely a work authorization program instead of being a deferred action program. And of course, the name of the program is Deferred Action on Childhood Arrivals, not Work Authorization for Childhood Arrival. So it's DACA, not WACA. That's, we're not part of the Sesame Street gang. So the thing is that, there seemed to be confusion around that, which is not great, I think, for the plaintiffs if, some of the justices are coming in with, maybe a mistaken perspective of how the program is supposed to function. But this is important because I think that there's been a very large public pressure campaign coming from immigration advocates in recent times, and this shows that there might have been some limits in their capacity to change the minds of the justices.
So, Cris, you brought this up a little bit earlier, and I want to dive into it in more depth. I'm wondering how this decision, when it comes down, could impact future presidents who were seeking to develop policy through executive or agency action. The last 3 administrations have done quite a bit of that, and I know you all have both written quite a bit on why doing immigration policy through executive action is not the way toward a stable and secure immigration system.
Sure. I'll take the first. I think, we've said litigation, executive action, that's not the way to get permanent status. The executive branch, Obama said it very clearly, and this administration, Trump administration agrees, cannot, by executive action, give permanent legal status to this group of people or any group of undocumented immigrants. They don't have that authority under statute. The courts cannot give unilaterally legal status to this group of people because it's not in the statutory authority to do so. That can only come from Congress. And no matter how this court case turns out, the ultimate fate of DACA and all of the dreamers rests with Congress. That's where it has to go. And frankly, Congress doesn't have to wait for the courts to decide this. Congress could act. And when the president rescinded the program, he said, I'm doing it with a wind down of 6 months. I want to give Congress a chance to come to a deal. Congress did try twice with the administration to negotiate a deal. Frankly, the administration didn't like those deals and didn't want them either. So there's lots of fault to go around. But that's the group of people. The solution has to come from the political branches. It has to come from the White House negotiating with Congress, Democrats and Republicans. That's who's ultimately going to solve this. And the courts can only sort of delay delay that and forestall it and give a temporary reprieve, but they can't solve it.
But I think more to your question, what does this do for the future? Obviously, this is happening with the context of the Democratic primary, where we've seen a lot of the Democratic presidential candidates talking about potentially relying on administrative executive action to be able to prioritize and pass through their immigration priorities. In fact, earlier this month, Bernie Sanders released his immigration plan, and he stated right at the beginning that he was going to rely on executive action to pull through his policies if Congress doesn't act. So when you're looking at a decision like this that potentially could limit the ability of presidents to be able to develop wide-ranging policies through executive action, this may potentially restrict the capacity of any future administration to be able to do this writ large. And so I think the question really is, if this decision goes through and they say not only did the president do it legally in terms of ending DACA, but also that the program itself is sort of illegal and maybe imposes additional restrictions on administrations to be able to pass this through, the question then is going to be for every single future president is, am I going to sort of take this route that's extremely limited, but I can get the priorities I want? Or do I go back to Congress and try to come up with a consensus, a way of sort of compromising and be able to develop legislative solutions? Because really that's what's going to happen. Of course, the gray irony, of course, is that President Trump has been using executive action in numerous ways to be able to sort of advance his own immigration priorities. So it is a little rich if the irony is that this decision actually ends up limiting executive action coming from a president who's been pretty happy to wield it all along.
Yeah. I would say, though, having watched a little of this, again, not being a professional court watcher, I'd be surprised, actually, if the decision that comes out of this isn't a fairly narrow one. Roberts has expressed uncomfortableness with wading into what he thinks are primarily political debates between the president and Congress or other opponents. I think that the likelihood that they'll rule on whether or not DACA was legal in the first place, if they don't have to get to that question, my guess is they won't. They will probably lean more heavily on whether or not the Administrative Procedure Act was followed, and that may be where the decision lies. I think there are other cases, particularly on some of these asylum issues and border issues, that are more directly about whether or not the president's actions were within the scope of the law. Those could have bigger impact, but I think my guess is that the court will try to keep its decision as narrow as possible on this one.
And court watchers have been also saying, watch Elena Kagan, who definitely has been a person who tries to come up with much more narrow compromises and sort of to thread a needle between the conservative and liberal wings of the justices. So she might play a role in here as well.
And again, Roberts and how much he wants to engage in this political battle. So two justices to watch. The thing to bear in mind, though, is we're not going to know anything probably for several months. Spring at the earliest. June, most people think, is when we'll see a decision, right in the middle of the campaign season.
So all of that, though, underscores what really sticks out for me, which is that the confusion about what's at stake in this case and the confusion that you mentioned, Cris, of Chief Justice Roberts in describing what DACA is, it really demonstrates the limits and the difficulty around doing immigration policy through executive action and the hoops that are required in order to make this kind of structure work.
I mean, the thing is that there's a whole body of literature that examines whether social movements can promote change through litigation, both in the legal disciplines and sociology, political sociology, and political science. And really looking at it from that perspective, what the consensus says from this research is that, yes, certain courts in certain eras of American history, especially the Supreme Court, were effective in doing this. But the moment that the court starts pivoting from this role of sort of advancing social change is when all of a sudden you start seeing the court not being that effective in producing that. And I think that, if we see this decision being a narrow one but against the program, kind of reinforces that picture.
I also think it's just fundamentally the role of the courts is not to be deciding the political matters. And I think, again, going back to what can the court do? The court can temporarily give a reprieve to the program. The court can extend the current status, but it can't really solve this issue. And again, the the purpose of litigation, I think, on behalf of the plaintiffs is not necessarily to solve the issue, but to gain a stay of execution, if you will, for this population. I think it's been effective to a certain extent in stopping some of these policies from immediately going through and granting breathing room. But again, a lot of things haven't gotten to the Supreme Court yet. This is really only the second of Trump's major immigration cases that's gotten there, right? The travel ban and this one. So there's a lot more to come, and we don't know which way it's going to rule. So at the end of the day, it's a risk. And again, I keep coming back to where the change has to happen is in Congress.
Yeah, because I mean, if you think about Brown versus the Board of Education, for instance, that was a decision that said you shall not promote segregation of Black and white students. But the court didn't say then you shall, advance civil rights. It was sort of a negative ruling on saying you can't do this. It wasn't creating an obligation to, promote integration in the United States or to expand the rights of minorities. That was the role of Congress. That's why Congress turned around and passed the Civil Rights Act, the Voting Rights Act, and other hosts of civil rights legislation, including the Immigration and Nationality Act of 1965, which people don't realize was a Civil Rights Act. But the thing is that really it was Congress who then saw this issue and said, we're going to take it up, we're going to change this. It is no different now. And I think that that's really the key thing, is that the court can only say, maybe it will limit the capacity of government to do things, but it's really up to Congress to take the step forward.
All right, then let's quickly, in the time we have left, game out what happens once the court rules on this case. If you're a DACA recipient, best case, worst case.
Okay. Best case scenario, the court says the administration did not end the program appropriately, but that the program was legal. Let's say it actually takes a position on that. Then that means that the Trump administration could go back and, by a different method, made a notice and comment rulemaking, rescind the program with full explanation of all of its legal benefits, and the program might then terminate sometime in the future. The worst case scenario is that the court says that the administration did it appropriately and terminated the program, and that termination is now in effect. What that means is that individuals who currently have status would have status only until the expiration of their existing work authorization. And anybody, it's not clear what happens to anybody whose application is still pending. My guess is that those could just disappear. And therefore, they would lose their work authorization and they would lose their protection from deportation. They could be deported. The administration has not said that they would use the information from these applications to go find people and proactively deport them. But then again, they've also made very clear that there is nobody who is a low priority for deportation. So any person who had DACA at that point and has no other status could be amenable to deportation if they encounter ICE in any circumstance. So, basically, they go back to where they were before the entire program started, in an undocumented status without work authorization.
And the mitigating factor here is whether or not Congress has legislation teed up in the case that the program ends. That can make a bad situation even worse, and a worse situation even worse, because the question is, we're really relying on the courts to be able to ensure that the program remains viable and online. But the fact is, if Congress really doesn't have anything teed up to be able to address the possibility that this program could end in the future, that will make the situation infinitely worse for not only for DACA recipients, but for Dreamers writ large.
Sure. So we know the House has passed legislation, H.R. 6, to permanently authorize and give green cards to this group, not just DACA recipients, but more Dreamers broadly, as well as address TPS status. So far, the Senate has not acted on that, although a group of senators the day of the Supreme Court hearings announced they would be introducing companion legislation. Democratic senators, there's no indication that Republicans are ready to take it up. So in terms of having something teed up, doesn't appear to be there yet.
All right, Theresa, Cris, that's a good place to leave it. Thanks as always for joining me. We will be back in 2 weeks. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. Just search Bipartisan Policy Center. This episode of This Week in Immigration was written by Cris, Ramón, and myself, and produced by Yafat Tawahara. That's all for now. Join us again next time on This Week in Immigration.